So welcome to the official start of our weekly webinar here at Gilfix and the Paul, the Gilfix Weekly Webinar. The topic today is estate planning for adults without children. If you're watching this and you don't have children, or if you have children, you might not want to include in your plan, this is for you. And we're going to talk about why having a plan is even more crucial if you don't have kids, contrary to popular opinion. And as we get started, let's go through some quick questions. You don't have children? Well, you're obviously not alone. I just looked this up. 1 in 6 Americans over the age of 55, over 15 million Americans don't have kids. This is and it's increasingly common. We see more and more of our clients come to us, and they don't have kids. Now, a lot of people think, well, I don't have kids, so I don't need an estate plan, right? I'm gone, and who cares? Wrong. It's absolutely crucial that you have an estate plan in place. Reframe estate planning. It sounds dry. It sounds like, where do my assets go, in a very careful way. It's really about preserving autonomy and empowering people you love and trust. And it's about preserving your legacy, ensuring that all that hard work you've put in through your life to save and to invest and to grow your estate and to provide that safety net, that it doesn't all go to waste. Let's preserve your life's work. That's what this is about. So as we jump in, Mike, why don't you go through the specific topics we're going to cover in today's topic?
Yeah, so this is basically our agenda for the day, and we'll insert a few other thoughts here and there. Maybe your questions will raise some other points. Okay, so if you don't do anything, what happens? What happens with your estate? What happens if you have needs? What does happen? Why it's worse if you don't have kids who can jump in and perhaps help out? What are the 3 basic fundamental documents that everybody needs to have in place? And sophisticated documents that reflect your wishes. How do you choose the right trustee or decision maker if you don't have kids? And by the way, just having kids doesn't always mean the kids are capable of doing this, but there's a presumption there. So how do you go about that? What's the thought process? What are the 5 biggest mistakes that people make when they don't have kids, when they're looking at planning or non-planning? And who should inherit your estate? What should you do with your estate if you don't have kids, which is kind of the presumptive approach? And how do we think that through? What are some points that we think you should consider as you make these decisions? And bottom line is, Mark alluded to this. We believe this so strongly. Your estate can make an impact. You worked hard. You developed an estate. Think positively. Think proactively. How can you leave something that makes an impact on issues or people you really care about?
That's right.
We'll develop that.
And we just have to point out, this is not legal advice. This is meant for educational purposes. It doesn't form an attorney-client relationship. We have to meet with you one-on-one for that to happen. So we want to empower you with knowledge and information that's crucial to your future. And this really is, and I just want to take one moment so you kind of see us. I know we're sharing slides. It's kind of hard, but hello, everybody. I'm Mark Gilfix, and this is Michael Gilfix. We're a multi-generational team at Gilfix and the Paul, and we're very proud of our heritage. And it's something that we've been in the Bay Area for over 40 years now.
Yeah.
Mike, is that right?
Is it not amazing? Yeah.
Yeah, it's crazy. So this is what we do. We live and breathe estate planning. That's the focus of our firm. We've served thousands of families throughout California, from San Diego all the way up to Wairika. If you're in California, we can help you, especially with Zoom. It's quite easy. We are very proud of being featured in national media. We've written books, we write articles about this. We focus really exclusively on planning for families, legal planning for families. And our goal is to provide extraordinary value and peace of mind and return on investment. So that's us. If you don't know us, and if you do, welcome again. I want to start off by telling a real story. Now, this isn't an image of Charles, but this is a true story. So Charles was someone, I think he lived in Mountain View. And he actually wasn't a client, and that's crucial here. A neighbor who had known him for years through helping him out came to us and said, I want to help Charles out. Now, Charles was a retired pharmaceutical, I think he was a chemist. He made millions during his life. He worked really hard. He owned his house in Mountain View, and he had millions in the bank. And he didn't have an up-to-date estate plan. He'd done a will decades before, but he had no estate planning documents. And his neighbor noticed that things were kind of falling apart, that his house was full of trash and it was unkempt and it was actually unsafe for him. And she wanted to know, hey, can I help him out? I want to help him get an estate plan into place. How can we make sure that we can help? And Charles didn't plan ahead. And the problem was Charles was losing his capacity. We met with him, And he actually, we had a good meeting with him. We started to develop a plan. Then he called later when he got a letter from us and said, "What is Gilfix in the poll? Who are you?" I don't remember meeting with you. He literally forgot the meeting with us later. We couldn't really move forward with planning. Here are the problems. His neighbor saw him falling apart. She wasn't family. She had no stake in his life. She couldn't really do anything to help him directly. He had to go to the hospital. He had some serious illnesses. No one was authorized to talk to doctors on his behalf or make decisions for him. As his capacity slipped over time, you know what happened? The state had to come in. Adult Protective Services took a look. The state got a conservatorship. A state agency went to court and had to take over his life. These were state workers. They are overtaxed. They don't have enough time to spend too much on any one person. So we had a state, despite his millions of dollars in the bank, that state had to come in and take over his life. And I don't know if he's passed away, but his plan said it was leaving money to some cousins that he hadn't talked to in decades. And he had charitable goals. He had other goals. We talked about them before he forgot them all. All of his money when he's gone is going to go to those cousins he hasn't talked to in decades, who he's not even friends with. It's a catastrophe. He lost his autonomy. His legacy is destroyed. No one, even people who wanted to help him, couldn't. And the state had to come in. So our goal here today is to make sure you never face the issues that Charles faced. That's our goal here today. Don't let that happen to you. So why don't we jump into the key and critical documents that everybody needs. If you're over 18, you need these documents. Mike, why don't you lead us through them?
Sure. So let's first talk about the durable power of attorney. And we'll go through each of these and spend just a couple of minutes. So if you're ill, if you're incapacitated, on the next slide, we make reference to the requirement that somebody has to be able to pay your bills.
Right. Well, the three key documents are revocable living trust, durable power of attorney, and advanced directive. We need all three of those in place. Everybody needs these. And we're going to go into the details, and it needs to be reviewed every 3 to 5 years. That's absolutely crucial. If it's been a while since you addressed it, you need it. And we help people throughout the state of California. So now let's jump in to powers of attorney.
We do help people throughout the state of California. We help each other sometimes too. Okay, so yeah, if you don't have kids, sometimes you don't think about these issues as much. And if you don't have a power of attorney, a durable power of attorney in place, who's going to be able to pay your bills? Who's going to access your bank account? Who can take care of you? So if you're ill and no one can pay your bills, the bills still come due. The only alternative, if you haven't done any planning and you lack the capacity to sign new documents or don't have the wherewithal to do it, a court-administered conservatorship may be needed. This is what Mark alluded to earlier with Charles, where he didn't do any planning and somebody just had to take over. Now, a conservatorship is a county-run process. A judge, who obviously doesn't know you, is in charge of appointing someone who's going to be named as the conservator. And they then kind of step into your shoes and have access to control of all of your assets. It isn't heartwarming to think that either the judge would have the public guardian office, the county office, or a professional fiduciary you don't know, have that person named. So if you don't have someone, if you don't have kids, if you don't have someone really close to you, this ends up, you end up with a stranger, somebody managing, paying your bills, and you don't even know who they are. It's not a warm, fuzzy feeling. So you need to do it right. You need to put together a power of attorney that is reasonably sophisticated. You got to think through who could be named. And in a couple of minutes, we'll talk about how you go through that process. You know, how do you find someone who's going to have the ability and the authority, with your approval, to take care of bill paying and generally manage things for you? So your durable power of attorney generally lets someone else take care of the business of life, the finances for you. You can find 2-page forms where you kind of check the box on durable powers of attorney. Sometimes they work, sometimes they don't. There's some provisions that need to be explicitly laid out in a durable power of attorney if the document's going to be effective. Not that length is always a virtue, but our powers of attorney tend to be 16 to 18 pages long, single space. And there's reasons for that. It isn't filler. Our fee is not larger because of the length of the document. I mean, our fees are reasonable. But you have to have detail in there. One example, the second bullet point, is that if you care about protecting assets, having help from government programs to pay the cost of long-term care. You have to plan. But if you become incapacitated and you can't do it, so the person named in your power of attorney, with your approval, if the language is there, can take steps to protect your assets and achieve Medi-Cal eligibility. It's a simple example of why details and sophisticated content matter in a durable power of attorney. One of the essential documents that you have to look at. But the trust is the more important document. So Mark is going to walk us through the revocable trust and its elements.
Yeah, and by the way, if you have any questions about long-term care, we brought that up here. We have a webinar, how to pay for the cost of long-term care, on the Gilfix Law YouTube channel. So check that out. But yes, why not just a will? Why should I create a revocable living trust or revocable living trust, also known as living trust, also known as revocable trust? There's a lot of terms you hear, but let's call it a revocable trust. This is the type of trust you would typically create for your assets. So you might think, why would I go to the bother of doing that? Well, if you just have a will, hey, a will is usually better than nothing. At least it can direct assets where you want them to go. But the problem is, if you just have a will, that means that your entire estate is going to be stuck in probate. And that means it has to go through the California court system. And as I like to say, if you love dealing with the DMV, you're going to love sticking your family and loved ones or your heirs with probate. It takes 2 years or more in many cases. It's totally public. Anybody can see your business. You might see once in a while when a celebrity passes away, there's articles about everything about their estate. You're like, why do we all get to see that? Prince, when he passed away, didn't even have a will. James Gandolfini had a will. Everybody saw what happened. It's all public. It's time consuming. It's very expensive. The fees are set by the court, not by your loved ones. They can be tens of thousands of dollars more than administering a trust. And a will doesn't help you while you're alive. It doesn't do anything for you. It's only after you're gone. And if you have property in other states, by the way, there would have to be a probate in those other states as well. So in California, and if you have a property in Nevada, there'd be a probate in Nevada as well. Having a trust keeps things private. It keeps things in the family or within the circle of friends and loved ones. The cost is much less to administer a trust than the cost of probate. It's private. That's the key thing. Nobody can see your business. No one knows where your assets are going. And a trust can help you while you're alive. We talked about the durable power of attorney for finances, a critical document to make sure your day-to-day finances are easily covered if you're incapacitated. But what about big assets? If you have a trust, you can assign assets to your trust, and your backup trustee can pretty seamlessly step in, even more seamlessly sometimes in a power of attorney, to help manage those assets. So trust and power of attorney work hand in hand to help you both while you're alive, and then the trust helps to ensure that your affairs stay private and avoid probate after you're gone. So really crucial. And a trust just allows a lot more flexibility. We can build in a lot more sophisticated mechanisms to make sure your legacy is really upheld. So again, if you just have a will, stuff is stuck in court. Now, what if you don't have a trust or a will? What happens to your estate? And if you have no kids, well, that's even more complicated. But as I said, if there's no will, well, your assets are definitely going to be stuck in probate. And your assets will be directed according to state rules. The state that you're living in will decide where your assets go according to the rules of intestacy. That just refers to state laws around where assets go when there's no will. And it kind of goes roughly according to your family tree. So assets could go to cousins or second or third cousins you've never met, or people you don't even like. So you have to create a will at the very least, but if you have any real assets, you really need a revocable living trust. So the bottom line is, don't let the state decide where your assets are going to go. Take charge, control it. We're going to talk about how you can, some choices you can make within that in just a moment. Let's talk about healthcare decision making.
And before we do that, just a really quick note. In one of the matters we handled for somebody who passed away, they were not our clients previously, these rules of what are called intestacy came into play. This and a relatively large estate here in Palo Alto ended up with over 56 beneficiaries, relatives. That's kind of how it worked. One of them, it's public record, was a guy named Garth Brooks, a very successful country singer. We had to send him a check for $5 because he was a fourth cousin of the decedent. I mean, it was crazy. It was crazy. So let's move on to advanced directives. Critically important document. This document lets you identify the person who's going to be your patient advocate, your surrogate, who has the authority to make healthcare decisions for you. And you can also be as explicit as you like about how you want decisions made. So who is going to have that power? If you don't designate somebody in this kind of a document, there's really nobody who can speak for you. So it becomes more a matter of judgment from the medical care professionals, maybe or maybe not doing what you want. So somebody needs to be empowered to have this authority in a well-drafted advance directive that doesn't just say, hey, you decide. It says, this is how I want decisions made. So as our clients know, we get into great details when we draft these advance directives. Critically important document. One of our resources on our website, by the way, is what we call the Healthcare Huddle, where attorney Mark Gilfix has done some very valuable writing about the role of and the importance of the patient advocate, somebody who can make sure that you're safe in the hospital. Hospitals are dangerous places. So we address that, we think, in a very reasonable, very responsible way. It all ties together with the need to plan in advance, find somebody who can be named. So on that point, here's the tough topic. Who's going to be named? To whom do you give these responsibilities? And first of all, we're looking at the trust, but other documents as well. The bottom line, whether you have kids or not, by the way, but certainly if you don't, you have to find a responsible person. Not your new best friend that you just met at the grocery store who was just delightful. Not somebody who was your friend 20 years ago. Somebody who's really going to accept and discharge these responsibilities appropriately. So do you have a family member like that? We all want to look to a family member, a sibling, a niece, a nephew. Ideally, you would find somebody there. By the way, it's a plug. Maintain and grow relationships with your family members, particularly if you don't have kids. I mean, you need somebody. And where do you find a level of trust? And this is the first place to look. Not blindly. You have to think, but a family member is always ideal. Somebody who should care more about you. If you don't find somebody within your family network, is there a close, really trusted friend, longtime friend? You've been through some grief or some difficulties with that individual, and you have reason to trust that person. Are they responsible? Are they going to step up and take care of these responsibilities? If you don't find somebody among your family or a close friend, you can go to the world of professionals. These are individuals rather than entities. There are individuals who are in the business of being a trustee. They're called professional fiduciaries. Many attorneys will serve in this role, particularly as a trustee, to take over management and make sure that assets are protected, that taxes are dealt with, et cetera. If you don't find somebody there, as we look farther and farther out, in a sense, there are institutions, of course, that are happy to be your trustee and to take care of your affairs, particularly if you have a large estate. So many of the institutions have minimums. If your estate isn't 2 million or more, or whatever the number may be, they won't take you. So you do have to be careful about that, but they do exist. Some are better than others. They're a resource if you don't have anybody else. There are a few nonprofit organizations, particularly in needy situations like special needs, long-term care. There are some nonprofits that will also serve. The next point is very important. A lot of individuals say, well, I have two nieces. I wanted them to serve together. We'll just say, for many, many reasons, we strongly recommend that only one person be named at a time. One of my favorite sayings is that if more than one person has responsibility, nobody has responsibility. So the buck needs to stop with someone. So you need somebody there. You need somebody who can be available if a crisis arises, emergencies happen, bills have to be paid, decisions have to be made. You have to really think this through. We are, of course, available to discuss this with you. It's not uncommon for a 2-hour meeting to have half an hour, 40 minutes of that go to this topic. Who do you choose and how do you go about that process? And you rethink it. You revisit this every few years. Again, particularly if you haven't named a close family member with whom you have a relationship. So it's an ever-going process to make sure that the right person has authority to take care of things for you.
And this is not a throwaway. This is the person who takes over your financial or medical life. So it's something you need to think about, because if you don't choose, if you don't name someone you don't know and might not like will be named in an emergency through the courts. Take control. Let's also talk about who will inherit your estate if you don't have kids? A lot of our clients who do have kids don't leave everything to their kids. But if you don't have kids, a lot of people think, well, I don't care. But you've worked so hard to save money, to buy a house or a rental property. You worked so hard to build up your portfolio. Every time you made a decision to get the garden view room rather than the ocean view room, to fly coach rather than first class, to get the chicken rather than the filet mignon. Every time you take steps to sacrifice, to work hard, those extra hours you put into work, the financial advisor you hire, that's all to build your estate. Chances are, hopefully, you won't spend it all while you're living. Why throw it all away when you're gone? So let's think about what are your dreams? What do you want to achieve with all these assets you worked so hard for? So there's a lot of different categories. So of course, family members would be the first category. We have a lot of clients who leave money to nieces or nephews or cousins who they love and who they want to care for, especially if they're deserving, especially if they're needy and good people, but need that financial safety net. Now, really importantly, if you have a family member you want to help down the road who has a disability, we can help you to set up the right structure. It can actually be destructive if you leave money to someone with a disability and it's not a huge amount. It can mess up public benefits eligibility, can expose them to nefarious third parties. So is there a special needs trust in place? We can help you to put a protective trust into place for one of your loved ones, or make sure that it's coordinated with what their parents may have set up for them. Crucial. You don't want to just leave money directly to people in many situations. Or if it's a niece or a nephew, we have many aunts and uncles who set up very protective family protection trusts. We've given a lot of talks on these, see other webinars, to protect assets from divorce and lawsuits and future estate taxes. If you're leaving a large chunk of your estate to a younger family member, very protective structures we can put in. Coordinate with the parents. If you're leaving to someone, a niece, nephew, a cousin, make sure their parents haven't put something into place for them. We can coordinate with that. So be thoughtful about that. Now, do you have a long-term friend? Not a Johnny come lately, that can be dicey, but someone you've known for a long time who you want to help out. And I'd say revisit this every 3 to 5 years, because we hear this, we look at people's old trusts and they're like, whoa, I literally haven't talked to that guy in 5 years. We had a falling out a few years ago. He's going to get 10% of my estate. Wait, what? People, they forget about it, right? You don't want to be leaving tens of thousands or hundreds of thousands or millions to people you don't even talk to anymore. And if you haven't addressed your plan in a long time, that happens more often than you might think. And the law doesn't care if you still know that person. All that matters is the name on the document. So those are categories. Longtime caregivers. Has there been someone who's gone above and beyond to help you? Now, this is dicey. There are many cases where this is taken advantage of, but we have many clients who very legitimately have left money to longtime caregivers or people who really made sacrifices to help them out. You have to be careful with this, but absolutely that can be doable. So now let's talk about charitable giving. And Mike, why don't you go through that? Such a wonderful thing.
Sure. We all, I think we go back one, Mark, please.
Sure.
Yeah, there we go.
Right.
Yeah, it's better to kind of think about this, sort of comprehensively as an introduction. You have an estate, whether it's 500,000 or 3 million or whatever it may be. And God knows there are so many issues and so many problems in the world. Some of them touch you directly, some of them indirectly, some cause worry. Even if you leave a small percentage of your estate, especially to local nonprofits, it's amazing what the impact can be. Well, if you own a home around here and you say, I'm going to leave 2% of my estate to the Alzheimer's Association or to the autism or to Post, which purchases property for the environmental preservation, that could be $50,000, $60,000, $70,000. One, two, even if you leave the estate to kids, I mean, that can be a wonderful gesture. It can make you feel good and it can have tremendous impact. So, think about that. Some percentage of your estate, regardless of anything else that you're thinking about. Charitable giving is often a component when we're looking at tax planning, reducing or avoiding estate tax, getting income tax breaks. So here's a couple of examples of the types of trusts that we set up for many individuals who are charitably inclined, but also want to get some benefit from their charitable giving while they live. There's something called a charitable remainder trust, a charitable annuity trust. You make a gift to a charity, you get income for life. These and other examples, by the way, are in my book, Beat Estate Tax Forever, where we talk about tax planning techniques that are appropriate. We don't have it on here, but for many of our clients, we've created family foundations. So you create a foundation, you put a team in place, maybe family members who are going to run it. You identify the purposes and you leave your estate to that foundation. No estate tax, no matter how big it is. It removes those assets from the taxable estate. So how many times have we heard people say this last line here on the slide, better to go to a charity than to the IRS? Most people can get behind that pretty strongly. So, we do encourage it. We do think it's one of the appropriate things that should be on your checklist. What do you care about? Is it education, your university, a school in your community that you care about? Is it healthcare? Is it hospitals? Are there organizations? I've already referenced the Alzheimer's Association, Post, Autism, Hillel, Catholic Charities. I mean, there's so many. None of them have enough money. None of them have enough money. So an impact, again, amazing opportunity for impact is for you to do something along these lines. You may care about issues more than particular entities. So education and scholarships, setting up a scholarship fund, something supporting your culture, your religion, your lifestyle. There are organizations that are working on that. And always the environment. We're in the Bay Area here. We are hyper aware of what the Bay Area offers, and most of us want to preserve it. So again, give it some creative thought. We think it makes you feel good and it has a tremendous impact.
Yeah. And I actually just want to jump in here. I have so many friends and we have so many clients, not everybody, who are so concerned about the climate change and the climate crisis. A small portion of your estate can make a huge difference if you support the right organizations in trying to save the planet for future generations. I'll just throw that in there. It's a cause I'm certainly passionate about.
Yeah. And it's not all or nothing. This is implicit in everything that we've said. Some go to individuals, some go to nonprofits. You choose the nonprofits. You may disagree with what Mark or I or your friend believes is the appropriate use of charitable money. It may be issues where we would disagree, but it's your money. It's your money. I will tell the shortest story. I once had a lady leaving her entire estate to a nonprofit organization that I personally abhorred. And I told her, every time I meet with you, I'm going to try to talk you out of this. But she stuck with it. It was her choice. We respected it. You choose where your money goes. So take it seriously. Realize you have the opportunity for tremendous impact. And let's be a little bit creative here.
Yeah, and I think it's just extraordinary the impact that you can have. I know we're hammering this, but I think especially for people without kids, charitable giving is just so wonderful. I think we're going to subscribe to our Gilfix Law YouTube channel, Gilfix Law, and we're going to do a talk on this in coming weeks. It'll be posted there. Let's think about the impact you can have. Don't leave money to a family member just because they're family. Now, if you want to help them, if you know them, if you have a relationship, great. But if not, that you don't have to do that. Or you can leave them a share of your estate. So we can help guide you. I encourage you to meditate on this. Even if you have a plan, think about this. What do you want to help? What causes do you care about? We have helped our clients direct hundreds of millions of dollars to charities over the year, and we're proud of that. And we've gotten many people to think about it who might not have done it otherwise. We're not going to redirect where your assets are going. We want to help you think this through. So you need that advisory team to make sure you're being thoughtful about it. So I think on that note, let's kind of sum things up, and we'll take just a couple questions towards the end. But estate plan, if you don't have kids, and we're going to summarize a lot of what we talked about, this is about taking control of what you can control. The world is chaotic. There is so much happening between foreign wars and inflation and fires. Luckily, this hasn't been too bad a fire season, and climate change and hurricanes, so much that we can't control. Let's control what we can. Let's control our legacy. Let's make sure people we love and respect and honor have the ability to help us when we need them. Creating and updating your plan ensures that your life and your affairs stay private, out of the courts, and within a circle of people that you trust and causes that you care about. That's what this is about. This isn't about legal documents. These three critical documents, we talked about this before, the three critical documents everybody needs: a revocable living trust, durable power of attorney for finances, and advanced healthcare directive. These are not just about the formalities of legal planning. This is about retaining autonomy and taking control of your own life. They need to be reviewed regularly. Life changes, situations change, and we can help you. If you don't have a plan, of course, we can help you to set a new one up. If it's been a long time, we can very efficiently help you to review your plan and make sure it's up to date. want to remind people, because of course we'd invite you to work with us. Our experienced attorney team is not just Mike and I. We have Francis LaPole, one of the best tax attorneys in America, Nick Klingenberg, Renee Conrad, wonderful, experienced estate planning attorneys. And this estate planning team, this is all that we really focus on. We have litigators in our office who are extraordinary. So if you have litigation issues, we can help. But we live and breathe this. So we know the nuances. We know the trade-offs you have to make. We have incredible depth of experience. And should you meet with us, because of course we would love to get the chance to meet with you if you have questions about this in person. Do you have an estate plan? If not, you need to set one up. We got to get these documents into place, and we need to do it right. And we can help sure that you do that. Help be sure that you do that. Has it been more than 5 years since you looked at your plan? You need a review. Stuff changes, laws change, your situation changes. Has there been a change in your life where you know that your plan needs to change, even if it's less than, it was a year ago, but your friend is now sick, who you named as a backup trustee? Well, we need to revisit that. We need to take a look at that. Do you have new dreams about your legacy? Has the world changed in ways that have reshaped where you hope for your assets to go after you're gone? Or have people come and gone from your life? Let's take a fresh look at that. We can help you think through this. So we would love to get the chance to meet with you. Gilfix.com is our website. We want to encourage you again to subscribe to our Gilfix Law YouTube channel for more. Spread the word. If you watch this, please like this video, subscribe if you're watching on a recording. If you're watching live, we'll answer some questions in a moment. But don't miss this opportunity to protect your assets and to retain control over your life and your purpose. We can help you with your dreams and with your legacy, and to ensure that the right people are empowered to help you when the time comes that you're going to need that help. So if you want to meet with us, connect us, you can always contact us through our website, but you can, if you'd like us to reach out to you proactively, if you're watching live, you can enter in the Q&A function, your name and contact information. We'll reach out to you to set a planning meeting. You can call us 650-493-8070, and you can go to our website, gilfix.com. We have many ways to contact us. We have a special page where you can click on specific concerns, gilfix.com/my-needs. So we're going to answer some questions in a moment. We had quite a few good ones. But I think if you take nothing else away from this talk, it's that you need to be thoughtful about this. You need to take control of your life. And if you don't have kids, it's actually more crucial to get this all into place, because no one is logically empowered to step in an emergency to help you. If you have kids and no estate plan, in theory at least, your kids would be the ones who step in. If you don't, we got to be more thoughtful about this. We have to plan ahead, and we can, of course, help you with that. So hope you got a lot out of this. We're now going to jump to some questions.
Sure.
Mike, do you see the questions you want to take?
Why don't I go through a few?
Yeah.
First is, please explain how a charitable remainder trust.
Carol
asks this. So if you get my book, by the way, Beat Estate Tax Forever, we have an illustration with some real numbers. So the idea here is that you typically have an asset that has appreciated in value. It may be real property, it may be stock. If you sell it, you're going to have a big capital gains tax. You hate that. Okay. So you take $1 million asset, you put it into the charitable remainder trust. The asset is then sold. There's no capital gains tax, because ultimately, after you pass, those assets remaining in the trust are going to go to a tax-exempt organization. Let's say it's the Alzheimer's Association. After the asset is sold, there's $1 million sitting there because there's no capital gains tax. You then receive income for life. You could set a fixed percentage, like 5%. You can set it up kind of as an annuity. There's some flexibility in terms of how that's done. But the idea usually is to take an illiquid asset, turn it into a productive asset, get income for life, do a benefit for the charity of your choice as well. CRT. And there's variations within the thing.
You're going to hear us say this a lot. There's a webinar about that. Look at the Gilfix Law YouTube channel on how to avoid capital gains taxes. And we talk in a little bit more detail about this. And yeah, on our website, if you're a client, we can give you a copy of Mike's book, Beat Estate Tax Forever. You can also order it. I think it's on Amazon. You can certainly order it through us. But if you work with us, we'd give you a copy. Obviously, we're happy to give our clients copies of books.
Okay. Next is Jan asks, is there any limit on charitable donations? Do they dollar for dollar reduce your taxable estate? Yes, they do. Yeah. The simplest estate plan under the sun to avoid estate tax says this. It says, to my family, my friends, whatever, I leave all the money I can leave without exposure to estate tax. Currently, that's $12 million, by the way. It's going to be $6 million in a couple of years. Everything above that amount, says your trust, it goes to charities. You just eliminated the estate tax right there. Dollar for dollar, it does remove those assets from your taxable estate. Okay.
Now, let's talk. We have any special considerations if no kids and a couple is unmarried? Yes, huge considerations. If
Huge.
you are not married, there are massive taxes. If you own a home and you want your home to go to your unmarried partner, your partner might face, even if you're leaving the home to them, a massive property tax increase, depending on how long you've owned it. We can help. Well, there are ways to avoid this. One way is just get married. By the way, there's an exemption for property tax increases there. But if you are with a longtime partner and not married or not domestic partners, you need to address these planning issues. There are all sorts of traps and problems that can come up. So we really need to be careful if you're unmarried. So talk to us. There's a lot of structures we can use to prevent that. But property taxes alone can be massive if you own a house. Any other issue you'd flag there, Mike, for
Well,
unmarried?
depending on the size of the estate tax,
Yeah.
I would just say that situation is abundant with opportunities. We have so many clients who are unmarried partners, and we go through this all the time. Some of them choose to, not that long ago, I had a couple, one proposed, they've been together for 50 years. One proposed to the other in my presence because they learned about the property tax protection, which is going to be massive, as Mark said.
Yeah.
So yeah, it's a very important issue. You really need to examine it.
Yeah,
Another one, by the way, asks, if you have kids you don't like or family members, can you disinherit them? Yeah, you can leave nothing to anybody. I mean, it's your choice. So yes, you can disinherit anybody you wish.
And I want to repeat just along those lines, because we get this question. I've gotten this question many times. Like, there's someone in my family I really don't like. I want to make sure they don't get anything. I heard I should leave them $1 from my trust to show. Do not do that. Do not. That's bad advice. It means that they get all these rights as a beneficiary of your estate, even if it's $1. So just don't name them. There are a lot of ways we can help ensure that your plan is explicit about that and that it avoids including people you don't want to even know about your estate. So,
okay,
good question.
So another one: should each spouse? My friend Anonymous asks, should each spouse have their own revocable trust? How do you address community property if there's two?
Good question.
If there's two, typically, yeah, community property is in one trust. If either spouse has a significant amount of separate property, maybe property they inherited, often there'll be a separate trust, but community property virtually always is in one trust, management, tax benefits, and more.
Yeah, we have a question about how we do business, our fees, and how we structure that. I'll just say up front that we don't do free initial meetings. We have a wonderful client community, and we want to serve everybody very efficiently and very well. So when we sit down with you, it is billed at the attorney's hourly rate, but we are there to serve you and to develop a plan to understand your issues. And from that meeting, we'll come up with a planning approach or a list of options. And after that meeting, we would let you know the specific fixed fees to complete the plan. So that initial meeting is about getting to know you, your situation. We live and breathe estate planning. We can very efficiently get to your issues. And then we would tell you exactly what the specific cost would be to complete the plan. And we're not talking about tens of thousands of dollars here. We're talking about the range for powers of attorney, $450 a person or so for a really sophisticated one. Trusts can range, it's a wide spectrum. There's so many types of trusts. Can be $2,200 to $5,000, depending on the types of trusts. But once we know your situation, we can really let you know. And if you do have questions about fit with us, we are happy to offer a 15-minute free Q&A call. If you just want to make sure we're a fit for you, you're a fit for us, we can just kind of explore your situation a little more and tell you how we, make sure that we're the right fit for you. We're not the right fit for everybody, and that's okay. So it can range, but you would know once we know your situation in writing what those fees would be. And I think one more question before we wrap things up. Mike, which one do you want to take?
Well, we are blessed with many, many, many questions today. We love it.
Yeah.
Would you prepare separate trusts for longtime unmarried couples? Maybe. Because again, depending on the nature of assets, if there's a home that's shared, there's reasons to get married and then share things in that context. But if you're not going to get married, yeah, you would have separate trusts. Then you really would you take care of each other. We would seek to maximize all estate tax protections for the two of you. But yeah, usually if you're going to stay separate, you do separate individual trusts.
And yeah, I think we got a few good questions about that. If you're with a longtime partner and you're not married, there are some very challenging issues we just have to be thoughtful about. We've worked with many couples in that situation.
Hey, I would call them opportunities.
Absolutely.
Countless
Well, opportunities if you're
opportunities.
working with people who know what they're doing. Without, if you're not working with us or a true expert in this area, there are a lot of landmines that can be accidentally sprung. So, what a pleasure to spend time with such good questions. So thank you so much. I think we've gotten a couple other questions, but again, if you would like to meet with us, gilfix.com/my needs. I'll just share that screen one more time. And please reach out if you'd like to meet with us, set it up. Don't wait. There is no benefit to waiting. You want to get these all into place as soon as you can. Once you get them into place, you might not need to touch them for a few years, but if you don't have them in place and something happens to you, you are in a very bad situation, and you might lose all control of your affairs and of your assets. So let's make sure that you're empowering people you love and care about to step in to help out. Contact us, gilfix.com. You can call us at the number there. I hope you got a lot out of this. Please subscribe, like this video if you're watching it as a recording, spread the word. Thank you so much for spending time with us. I'm Mark Gilfix. This is Michael Gilfix. We are Gilfix and the Pole. I feel like we're a band saying goodbye. We are Gilfix and the Pole Associates. We hope you got a lot out of this. We hope everybody's staying safe, sane, and healthy, as my mom likes to say. And we'll see you next week. And hope to meet with you in person.
Okay,
Thank
bye
you,
all.
everybody. What an amazing afternoon. Hope everybody's good.